Hello, everyone. This is Carlene Sue, and I just want to give you a brief outline of how this talk will go for the next hour or so. So this talk is going to be about 45 minutes. Lester will give some basics on Stark Law, which will be about 15 minutes or so. And then we have many different scenarios that Jean and Lester will both go over, and that will last about 45 minutes. We will have a time for some questions and answers. Please type your questions in the chat, and I'll keep track of them, and I'll then ask our panelists at the end of the talk. Just to let you know that the handout is on the right side, and this is Stark Law for Rheumatology handout. Go ahead and download that. And we are recording this session here, and Jean will let you guys know later on how to view it. So that's the housekeeping issues. My name is Carlene Sue, and you guys probably know me from Rheumatology Private Practice Group on Facebook. I also posted about this talk on the Private Practice General Group. So not all of you guys are rheumatologists, but I thought this topic is very pertinent, not just for rheumatologists, but for all independent private practice physicians that may have ancillary revenues, and the questions about how to handle those revenues when you have physicians that are owners and also employed. And so I was employed after fellowship in 2015 and started my own practice in 2015 until now. Really passionate about encouraging our fellow physicians to be in private practice, so we could take control back on how we want to practice. So, this is really daunting and challenging, and we really have to stay on top of all the regulations that affect how we practice. We can't be ignorant of this. So, Stark Laws is one of those many regulations that we need to understand. So I want to introduce you to Jean Acevedo. I actually learned about her from many talks put up by NORMS, and that is National Organization of Rheumatology Management. She gave fabulous talks about coding, auditing, and so she's just an expert in this field. She has 30 years of healthcare experience, and so she has expertise in all facets of rheumatology documentation, coding, working with rheumatology practices, small and large. She did chart audits, educate physicians, MPPs, and staff. And she's been a speaker at many, many different meetings, including the American College of Rheumatology. And so a lot of her talk really is relevant to all the practices. So Jean is going to introduce Lester.
Thank you, Dr. Sue. Good morning, everybody. Lester Perling and I are delighted to provide you with this information today. This is indeed probably one of those burning topics for doctors, one of those ones that you may or may not have any real solid knowledge, right? So what you hear about in the doctor's lounge, that old saying. So we are very, very lucky to have attorney Lester Perling this morning. I've known Lester for probably at least 20 years. I have the pleasure of working with him with some mutual clients when there's the need for a compliance/coding consultant and the attorney. I like to say, Lester actually doesn't hear me say this in front of him, but if there were more attorneys like attorney Lester Perling, there wouldn't be any bad lawyer jokes. So, and the main reason why I sought him out to speak today with me on this topic is that Mr. Perling is indeed one of the recognized experts in the law field on the Stark Law. So we couldn't have anybody better. I do want to remind you, I don't remember if Dr. Sue said it or not, but if you look at your GoToWebinar toolbar, that's probably on the right of your screen, and the handouts, there is a handout, a PDF file that you can open, you can download, take notes on, that mirrors this presentation today. So with that having been said, it is a Saturday morning. Lester, I'm going to turn it over to you for the basics.
All right, thank you, Jean. Good morning, everybody. It's a pleasure to be with you on this Saturday morning. So the Stark Law has been around now for about 20 years. And a lot of folks have forgotten what prompted the Stark Law in the first place. And the Stark Law was really a response to what some data that tended to demonstrate, at least, that when physicians had ancillary services embedded within their offices or that they owned separately, the utilization of those services was higher than when they did not. And the presumption, I don't know that there was any data to support this, was the presumption was that that was simply for economic reasons, and therefore Congress passed the Stark Law to place some hurdles, if you will, in front of physicians in terms of making money off of ancillary services. That originally only covered clinical lab because that's where the studies were done, but then was expanded to include all the other designated health services we'll talk about in a minute. There is some movement, there has been for a while, but it looks like it might be picking up some political steam to actually repeal the Stark Law or to severely revise it and cut it back. And in fact, the Centers for Medicare and Medicaid Services, which is the agency responsible for regulating the Stark Law, supports the notion of repealing it. I think they find that it hasn't been useful. The exceptions kind of undercut the prohibitions, and it just absorbs too much of their time and attention. But we'll see, we'll see how that goes. Of course, only Congress can repeal it. And, we know that Congress is, over the last many years, hasn't been overly functional. So we'll see what happens. So let's talk about some of the Stark Law basics. Jean, I have no way to control the slides, so there we go. Thank you. So what does the Stark Law actually do? So the Stark Law prohibits a physician from making a referral to an entity, and these words that are bolded we'll be talking about more specifically, so don't worry that I'm skipping over them, for the furnishing of a designated health service, or DHS as it's commonly known, for which payment may be made under Medicare. And you'll note in parentheses, I added Medicaid, because the Department of Justice and whistleblowers, who are the primary enforcers of the Stark Law, as it turns out, as well as some courts, take the position that Stark Law not only covers Medicare, but Medicaid as well. CMS has taken the position that it actually doesn't directly cover Medicaid, but despite that, there have been several courts willing to accept the notion that Stark covers Medicaid. So I generally advise my clients to just assume that's the case and treat Medicaid and Medicare the same for purposes of Stark. Note that there is an exception for under the Stark Law with regard to services that are covered by Medicare Advantage that are not paid on a fee-for-service basis. I know that many specialists are often paid fee-for-service by Medicare Advantage plans, but there is an exception for that. To keep going, if the physician or an immediate family member, I don't think we have the slide here, but that includes spouse, children, parents, grandparents, siblings, in-laws, so it's a pretty long list. So if one of those individuals has a financial relationship with an imaging center, let's say, for example, it's as if the doctor, him or herself, also has a financial relationship. It's imputed to the physician. And as I mentioned, the other element is that the physician or immediate family has to have a financial relationship with the entity. One of the things that is troubling for physicians, because this is a legal concept and can be hard to understand if you're not a lawyer. Many statutes, in order to be sanctioned under them, like most criminal statutes, almost all criminal statutes, the False Claims Act, in order to be found liable or guilty, there has to be some demonstration of some level of intent. Either it's specific intent to violate the law or a general intent to do those things that in fact violate the law, even if you don't know about the law. Stark is not an intent-based statute, and that means that it's a strict liability statute. So a strict liability statute means that whatever your intentions are, good, bad, or indifferent, whatever you understood or didn't understand or thought or didn't think, is irrelevant. If you violate the Stark Law, you are liable under the Stark Law for the sanctions we'll talk about. The best example I can give that I use routinely is speeding. If you're speeding up the freeway and let's say the speed limit is, as it is where I am at the moment, New Mexico, it's 75, fortunately, and you're doing, 80 and you get stopped. And you tell the police officer, look, I'm only doing 80. All these other cars are doing 100. You didn't stop them. I'm in a hurry because my mother is ill and about to die. It doesn't matter. You can still get a speeding ticket. It doesn't matter the reason. It doesn't matter that other people are doing it also or doing it even worse than you. You're liable if you violate the Stark Law. Period. End of story. Next slide, Jean. So what are the penalties? So first, under the statute itself, is denial of payment or having to make a refund. Potential civil money penalties of up to $25,000 per claim, which, as you can imagine, could be a huge amount of money, and exclusions from federal and state programs. The CMS, the Centers for Medicare and Medicaid Services, has the authority to deny payment or impose CMPs. I'll tell you that, to my knowledge, they have never imposed a CMP for Stark violations. CMS, despite the fact that it's within their jurisdiction, has never shown much interest in enforcing Stark at all. It's just never been that excited about it. However, there is a group that is very excited about enforcing Stark, and they do it all the time. And those are your friendly whistleblowers, the people that identify within your practice that you're violating some law related to a federal healthcare program such as Medicare, Medicaid, and file a suit on behalf of the United States as a whistleblower or relator under the False Claims Act seeking damages. And the Stark Law is very commonly the basis for False Claims Act suits. A False Claims Act suit is potential trouble because it has liability imposed of treble damages. So what that means is for every false claim, the amount that was claimed, not the amount that was paid, but the amount that was claimed can be trebled, and you could be required to refund that, to pay that to the government, back to the government, or back to the program, or typically will go to the Department of Justice. And that's up to treble damages. Additionally, the court can impose up to a almost $23,000 per claim penalty. And a claim isn't a single 1,500. A claim is every line on that 1,500. So if let's say you have a clinical laboratory and it's not properly structured and you shouldn't be referring to it, but you are, each lab test, which might be a line on a CMS 1500 claim form, is a separate claim and can be assessed a $23,000 penalty. So it's both damages and penalties. I mean, so financially, it can be ruinous if you're the defendant in one of these cases under the False Claims Act, which is why well over 90% of those cases tend to settle if they survive in court a motion to dismiss. The other thing I would like to note is that if you do submit a prohibited claim under Stark because there was a referral prohibition without an exception, and you get paid for that claim, that also is considered an overpayment. And we're not going to talk about that today, but keep in the back of your head that that requires notification to Medicare and to Medicaid and an affirmative refunding of those monies. All right, so what's a simple example of a referral? Dr. X owns his medical practice, and Dr. X also owns a clinical lab, and he makes a referral to that separate clinical lab. That's a real easy example of a potentially prohibited referral. Next slide. Somewhat less simple are some of these other financial relationships. For example, the physician has a relationship compensation arrangement with a hospital to be a medical director, to rent office space in the medical office building. and then makes a referral. Absent an exception, those referrals would be prohibited. And although it's not clear on the slide, and I don't think we have a slide that shows it, the financial relationship in terms of a compensation arrangement can go either way. So let's say you reverse the arrow for rent payments. Let's assume the hospital rents space in a doctor's office, which happens sometimes, even though the payments are going from the hospital to the doctor the doctor's renting space from the hospital and the doctor's paying the hospital. So whichever, I got myself muddled up, whichever direction the money is going, it's a compensation arrangement that's covered with Stark. It isn't just about money coming to the doctor. It can also be money going from the doctor, for example, to rent space in a hospital. So next slide, Jean. So what is a referral? And most of you who are listening will think in your head, well, everyone knows what a referral is. Well, forget that because you don't. I was a hospital administrator for 10 years before I went to law school. And so when I see the word referral, I react much like physicians would. It means I, doctor, send you, patient, to my laboratory to get a laboratory test, or I send you to ABC Hospital to have surgery. Those are common examples of a referral, simple enough, and that's what most of us think of as a referral. But under the Stark Law, it's much broader than that, as you see on this slide. So in addition to the classic referrals, a referral is also a request by a physician for consultation with another physician and any test or procedures the other physician orders, performs, or supervises. So let's assume that a physician sends a patient to a oncologist and for a consultation on possible cancer. And then the oncologist sends the patient back to get an MRI owned by the original referring physician. That referral by the consultant, the oncologist in this example, for that MRI is as if the physician owner, the one who referred the patient to the oncologist, ordered the MRI himself. It's attributed or imputed to that physician. Not as common a scenario as the next one. The next one is requesting requesting a service or creating a plan of care that includes the service. So here's a really common example. The doctor owns a pharmacy, which is covered by Stark, outpatient prescription drugs, and writes a prescription for the patient to get an antibiotic. The patient goes to the pharmacy owned by the doctor. The doctor didn't send them there. The doctor didn't even tell them about the pharmacy. Patient has no clue that the doctor owns the pharmacy. It just happens to be convenient. Even though the doctor did not in any way, shape, or form send the patient to that pharmacy, that is considered a referral by the patient showing up at that pharmacy, which means essentially that pharmacy would have to know to turn away any patient with a prescription written by the physician owner, or if they fill the prescription, they can't bill Medicare or Medicaid or a Medicare prescription drug plan, which also is covered by Stark. They would have to eat that prescription. So this last bottom arrow is the one that is most commonly implicated and the one physicians most have a problem with, because they wouldn't see that as just ordering something in their heads isn't a referral. Next slide. So what is a referral? A referral is of a DHS that is not personally performed by a physician. There are times when the physician will personally perform a DHS. For example, ultrasound. Ultrasound is a DHS, and I'm aware that oftentimes a vascular surgeon, for example, will do an ultrasound himself rather than have the tech do it, or an ultrasound performed by a OBGYN sometimes. So if the physician personally performs the DHS, then it's not a referral for START purposes, and it's okay. Also, a referral does not include some tests ordered by the following specialists: pathologists, radiologists, and radiation oncologists. And if assuming those services are being done based on consultation from another physician, if a radiologist, as some radiologists are now, or interventional radiologists, and so they are seeing patients and perhaps ordering services, that might be a referral, unlike Dr. Jones ordering an X-ray and then the radiologist performing the X-ray. Next slide. So here's a list of designated health services. Some of these speak for themselves, some of them don't. They have definitions. Some of them are actually based on the CPT code, and every year CMS publishes an updated list of CPT codes that are included within these definitions. I know that's true for clinical laboratory, it's true for radiology and some radiation therapy. Some of the other designated health services aren't CPT based, they're definitional based. And so you can read this list for yourself. The ones most applicable most often to physicians, depending on their specialties, of course, that might be performed in the office are things like clinical lab, outpatient prescription drugs, radiology. Those are the things most typical in doctors' offices. Some dispense DME, but anyway, that's the list. The entity that you can't refer to is the entity that either bills or performs the DHS. Next slide. Financial relationship includes ownership, and it also includes any form of compensation arrangement, which we talk about there. The definition of remuneration is broad. It's on the next slide. It not only includes money, but it includes any other benefit, which can be in kind, which we talk about in the next couple slides. So these are examples of benefits, include payment, of course, but use of office space, personnel, continuing medical education, et cetera, et cetera. Next slide. So there must be an exception if it's covered by the Stark Law. There has to be an exception. The relationship has to meet an exception, or the referral is prohibited and the submission of the claim is prohibited. Next slide. Finally, there are a lot of exceptions. We can't go into all of them. We're going to go over some scenarios, which I'll talk about some of those exceptions that most commonly apply to medical practices. Most recently, though, there were some additional exceptions. One of those relates to value-based arrangements, which we're going to talk about a little bit more in one of those scenarios we'll be talking about. So that's a really quick, and I took too long, but it's hard to do too quickly, basic kind of explanation of the Stark Law. So, Jean?
All right, thank you, Lester. And don't worry about quote unquote too long. It took whatever time it took so that the doctors and anybody else attending may have some basic understanding. So now let's try to apply this to the rheumatology practices. And this is where, guys, ladies, attendees, if you think about something as we're going through these scenarios, and Lester and I going back and forth, please type your questions in the chat box, and Dr. Sue will be looking for them to interject and add to this discussion. So outside referrals. And Lester, I've got to tell you, this was the first time that I've heard, so thank you for that because it's important, that last little arrow that you showed on what was a referral, where the example was like, I have a pharmacy, I give you a prescription, and unbeknownst to me, you go to my pharmacy, right? That was a little bit scary to me. So I'm glad to have that.
That's shocking to any physician I talk to about the Stark Law. And in fact, I didn't mention it, but we probably should mention, Jean, that the Stark Law and the federal anti-kickback statute that most of you at least probably have heard of are somewhat parallel statutes. One, the kickback statute is a criminal statute, et cetera. But it also talks about payment for referrals. And a court recently interpreted that law in the same way. A doctor signed a plan of care for a home, or signed plans of care for home health services, had no idea what home health agency the patients were actually going to, didn't care, didn't order a particular agency. All the doctor did was sign the plan of care. And that court found that the doctor was could be convicted under the kickback statute for making referrals in exchange for remuneration simply for signing a generic plan of care. So,
Wow.
yeah, when you think about referrals these days, you got to think way more broadly than your training and your experience would suggest.
Oh, yeah, for sure. So, since we're talking about referrals, and the majority of rheumatologists that I've had the pleasure of working with have x-rays in their office.
Mhm.
So, and I know there are exceptions and all of this, but so I'm performing x-rays. I order them and my technologist performs them and I interpret them on patients routinely in my practice. Let's make believe I have elevated myself now to a physician with specialty of rheumatology. But there's doctors in my building maybe, right? That don't have x-rays and they know I do a great job with musculoskeletal x-rays. Can I accept an x-ray? I'm sorry. Can I accept an order for an x-ray from the doctor next door to me, down the hall, down the street, and be able to bill for that? Is that okay with Stark if I accept an outside referral for x-rays or not?
It is okay. So, or in order for you to order x-rays within your own office, you have to meet an exception. You don't have to meet an exception to accept referrals from anywhere outside, at least according to the Stark law. Caveat, there are state laws that also regulate this area. For example, in Florida, where my office is and where Jean's office is, we have something called the Florida Patient Self-Referral Act, which is the Florida version of the Stark law and actually predates the Stark law. The Stark law was in part modeled after the Florida law. Under the Florida law, the physician, in order to meet an exception, cannot accept outside referrals. As a general rule, there's a complicated exception for imaging, but the point being, the Stark law, yes, but you always have to understand state law as well.
All right, thanks. All right, so what's our next one? Relative to physician compensation. When developing a physician compensation formula based on productivity related to ordering or supervising services that are considered designated health services, so there's x-rays, therapy, since it's outpatient prescription drugs, so infusion and injections. Does it matter if the doctor is a W-2 employee or if it's a part-time independent contractor?
It can, it might, and it might not. So there are a number of exceptions, as I alluded to, under the Stark law that allow physicians with financial relationships to refer to that entity. So here we're talking about the physician's own practice that the physician owns. But physicians who are employed by the practice or contracted with the practice also are covered by Stark because they have compensation arrangements. And so if they're going to order DHS like x-ray or therapy or whatever within the practice, that financial relationship, that compensation arrangement has to meet an exception. And to complicate matters further, there are multiple exceptions that could apply depending on the situation and the relationship, and how a physician can be compensated is different under each exception because we really don't want to keep things simple here.
Sure.
I'll make this side personal note that I'd have to say the Stark law has benefited my career and my bank account greatly. So I'm going to thank Congress for that. But anyway.
Yeah, but as I'm listening to you, I'm thinking, if I was a physician, right, and I had designated health services, and for the specialty that we're speaking to this morning, rheumatology, that's almost 100% of the time, right? I can think of one rheumatologist, a solo physician that I've worked with that has no answer. Oh, I take it back. He does have 2 wave tests in labs. So nope, not even him, right? So this type of scenario becomes really important since there is no intent required under Stark, right? For docs to keep
Yep.
us safe. All
Yep.
right. So, sorry, go
You
ahead.
have to make the exception, and you back up, Gene. I'm going to talk a bit more
Sure.
specifically if it's so. Yeah, so to make the referral in this scenario, you do have to meet each element of the exception. And unlike horseshoes, close does not count if a whistleblower comes after you. You have to meet the technical requirement of each exception. And courts have been pretty strict about enforcing that requirement when these cases are in front of them. So to get a little bit specific, given the limited time we have here, most physicians, in order to refer within their own practices, rely on the in-office, what's called the in-office ancillary services exception. And that is, just like the name implies, it applies to medical offices where services are part of that medical practice as opposed to the doctor owning a separate entity. And in terms of the physicians that work within that entity who are either employed or contracted, it doesn't matter. That distinction makes no difference. They can be paid in the same way and bonus based on personally performed services or those incident to their services, which include outpatient prescription drugs, because that's how they're billed, and that's a little bit complicated. But that exception gives you the most flexibility because it also, in a different part of it, it allows bonuses based on profits from DHS, which we don't have time to get into, but can also be shared, if shared properly, with both employed and independent contractors, physicians. If you don't fit within that exception for some reason, or you choose not to for some reason, there are exceptions for employment relationships, and there are exceptions for independent contractor, or an exception for independent contractor relationship. And there's also a third exception that can be used for any fair market value relationship. And those have different parameters for how you can compensate the physician. Again, don't have time to go into them, but understand that there are different exceptions to choose from, theoretically, that might best, figure out which best suit your needs. But for most, the vast majority, not just most, but the vast majority of physician practices, the in-office ancillary services exception is the one that provides the most flexibility in terms of compensation. And it's the only one that can be used if a physician owns the practice. Because that's the only exception that will apply to physician owners. So if Dr. Smith and Dr. Jones own the practice and want to refer within the practice for designated health services, the practice has to fit that exception. And that's why it applies to most. If a layperson like Jean and I happen to own a medical practice like we could in Florida, but perhaps not in other states, we don't have to fit that exception because we're not physicians who are referring, and we could fit that exception potentially, or we could use one of the other exceptions. So again, demonstrates the complicated nature of it, but gives you a little bit of an overview of how that works.
So Lester, with what you just said, tell me if I'm jumping to a wrong conclusion or maybe not. Mm-hmm. So is it then the case that Stark only applies to a physician-owned physician practice?
No.
No, okay.
Because if you and I own a medical practice, let's say we own a rheumatology practice in Florida, and we have X-ray, we perhaps administer infusion and other drugs. Maybe we have rehab, might even have a lab. Because we then have doctors that we either employ or we contract with, those doctors have compensation arrangements with our medical practice. And the Stark Law applies to them equally as it would as if you and I were physicians and owned the practice.
All right. So, and that would be the same for hospital employed physicians then, I guess?
Well,
yes. Yep. Okay. Thank you. All right. What's this next one coming up? All right. If we carve out Medicare payments, can we distribute ancillary service revenue based on who ordered the service? And for this, it might be any of the things that we just talked about. It could be the clinical laboratory tests, injection and infusion revenue, x-rays, musculoskeletal ultrasound. If we do it just for non-Medicare payments, can we, without any fear of violating any laws, particularly, well, I shouldn't say any law, without fear of violating the Stark law, can we do that?
Well, technically you can, because the Stark law only applies when the designated health service is payable by Medicare and perhaps Medicaid.
Right.
And not even any other federal healthcare program. Like, if you may be familiar with TRICARE. It doesn't cover TRICARE. However, that's only the Stark law, and so again, you have to look at other laws. One of the other laws that could be problematic with that type of distribution could be the federal anti-kickback statute. While you're excluding maybe Medicare, if you're not excluding TRICARE, for example, which is a federal healthcare program, as I mentioned, or Medicaid, and you're paying directly for referrals, this gets complicated, but that could be a violation of the criminal federal anti-kickback statute. But it could also be a violation of many state laws, either states that have their own form of the Stark law, or states that have, as most states do, also kickback prohibitions. For example, and again, using Florida, if a medical practice pays a physician based on referrals of ancillary services, that actually could be a crime under Florida law and could also result in discipline under the Medical Practice Act against a license as an illegal fee splitting arrangement, even to an employed physician. So there's a lot of potential risk in doing that, and the level of risk may depend on who you receive payments from and what state you live in.
Okay, thanks. And I don't think I actually wrote this one up, but as I'm listening, I think there's another scenario that if we can address, I think would be great. So
actually, I have a question for Lester. So just to clarify, Stark law applies to Medicare payments, but in some states, there may be state laws that also apply to non-Medicare payments.
Correct.
And then just a question about owners versus employee physicians. So let's say their practice has 2 owner physicians and they employ 10, physicians. Mm-hmm. How do you distribute the ancillary services? For example, they all order x-rays, they all order, infusion services. The infusion is more incident to, because you bill the infusion codes, right? And that's under the doctor's name that ordered the service. Right. So are those 2 scenarios different, x-rays versus infusions?
They can be, yes. So in terms of profit distribution under the Stark law, again, in your scenario where you do have owner physicians and then 10 other physicians, let's assume they're employees or contractors, it doesn't matter in the group, you have to fit the in-office ancillary services exception. Now, there's a number of ways you can distribute profits. Depending on what the owners choose to do. The owners could decide all profits are going to us, and that's fine. And they can split them based on their ownership interests. They can split them based on age or seniority or whatever, as long as they don't split them directly based on the volume or value of who ordered the service, even though they're owners. But the owners could decide, we want to share this with with all of our physicians. So yeah, they can be shared, again, so long as that profit sharing isn't based on directly on the volume or value of what they ordered. So for example, if you have 10 doctors and Dr. Jones ordered 50% of the x-rays because he likes to order x-rays more than anybody else, he can't just get 50% of the x-ray profits. The profits have to be distributed to the other physicians, again, not directly based on their volume or value. So it could be based on their personal productivity, like RVUs. It could be based on seniority within the group. It could be based on quality measures. Anything other than directly related to the volume or value of what they order. Now, infusion is different because infusion is an incident to And so incident 2 can be shared based on who ordered the infusion. So it can be shared based on the doctor whose service it's incident 2 to, not necessarily the supervising physician. So if I'm Dr. Jones and I order infusion, and that's part of my plan of care, and then that's administered by my infusion nurses, I can be directly compensated under the Stark Law based on that infusion as an incident 2 service.
But is that just the administration, or is it the drug as well?
There's no clear guidance on that. I think there's a decent argument that it would be both, because I think both are covered by drugs and biologicals are covered by incident 2 benefit, and the infusion activity performed by my employee, my nurse, is technically also incident 2. So I actually think the better argument is it's both, but there really is not exactly clear guidance on it. And we've been asked by a few practices, including some rheumatology practices, about that very issue. But that's the best I can tell you, because it's not specifically addressed.
Right. Thank you. Thank you. And obviously with all of these things, just for the audience too, remember these are all situationally based, right? So depending on the specifics of everything. All right, let's see if we did this one already. I think we did, but let's just make sure. If we provide x-rays in our office, can we bonus practice physicians for their referrals?
No.
No, not if it's based on the value or volume of the referrals.
I mean, this question is right, their referrals. So, yeah.
Now, ultrasound is something that rheumatologists are doing an awful lot. Diagnostic ultrasound, musculoskeletal ultrasound, as well as ultrasound guidance. So is ultrasound guidance the guidance, right? So I'm doing a knee injection and I'm using the ultrasound machine to help guide the injection procedure. Is that different from a diagnostic ultrasound, which would be designated health services? Or is ultrasound not even covered under Stark? But then, of course, some states like Florida, you mentioned, are mini Stark law, nothing mini about it, does list ultrasound. So is there a difference for the rheumatologists in how they handle revenue and referrals based on ultrasound guidance or diagnostic ultrasound?
There is a difference. Ultrasound, first, a diagnostic ultrasound is a Stark designated health service, first of all. However, when imaging is used incidental or as guidance in the context of a therapeutic procedure, or even in other, not applicable to rheumatologists, but for example, a cardiac cath, where imaging is used to guide the placement of the catheter, but it's again incidental. What's really being done is the placement, is the catheterization, or in rheumatology, the injection. In that situation, it's not a DHS. If the ultrasound is being used for diagnostic purposes, it is a DHS.
Oh, thank you. I'm glad I came up with that question. It was a burning question. It was a burning question for me. I don't know if any doctors had ever thought about it, but this was one from my convoluted mind. All right, clinical lab. If we have an in-office lab, how do we handle it when a patient comes? This is something that comes up. I get asked about this. Patient comes in for a physician visit with the rheumatologist, and the patient brings an order from their PCP, some other physician they're seeing for lab work, and the patient wants to know if, rather than having to go to LabCorp request, and since my rheumatologist is ordering lab today, can he or she just add those tests to the order and the performance of the test, bill and collect for them?
From the Stark Law perspective, yes, that falls into the same category as the doctor asking the rheumatology practice to do an X-ray. The rheumatology practice here, at least under the Stark Law, could accept these outside tests and do them if they choose to do so, and they're properly certified to do them. Again, state law might speak to that issue. For example, in Florida, you couldn't do it, but from a strictly a Stark Law perspective, it could be done.
Right.
Because the The test ordered by the PCP, now, if the PCP in some fashion has a financial relationship with the rheumatology practice, not likely, but possible, then perhaps not. So here's a scenario, and this goes to what you said a minute ago, Jean, about this is such a fact-based statute, you can never make broad generalizations. Let's assume the PCP rents space in the rheumatologist's office. That rental agreement is likely, there's situations where it may not be, but it's likely that's a financial relationship under the Stark Law. There's a compensation arrangement, payment of rent. And then in order for the PCP to be able to refer to the rheumatologist lab, that particular agreement has to meet its own exception, which there's a space rental exception, and there's an equipment rental exception. If it doesn't meet that exception, then no, the rheumatology practice could not accept those referrals. So I know you didn't ask about that, but that's a really good example of how fact-specific the analysis has to be when you're trying to make sure you're compliant.
Yeah. Thank you for that additional perspective. All right, so I guess this is more about the incident to personally performed services. So I have a physician assistant and or a nurse practitioner. More and more rheumatologists are indeed employing non-physician practitioners. They're salaried. They're not eligible in my practice for any ancillary bonuses. That's only for us doctors. Can the practice bonus the non-physician practitioner's supervising or collaborating physician for the designated health service that non-physician practitioner orders and or refers?
Yes, they can, assuming that the physician, the supervising physician or collaborating physician, did not instruct the nurse practitioner or PA to order the test. Mm-hmm. So, for example, I make an appointment with my rheumatologist. I come in, I see the nurse practitioner orders the x-ray. I get the x-ray. The doctor is Dr. Jones in the practice, happens to be the collaborating physician for that nurse practitioner. And so theoretically, at least a supervising, theoretically then he or she could be, the physician could be bonused based on that x-ray. They didn't order it. And a side note here, just so everyone's clear, the Stark Law does not apply to non-physician practitioners and their orders, only physicians. But let's say the scenario where the nurse practitioner sees the patient, and then it's a complicated patient, and they walk out of the room and they ask the doctor, say, hey, I got this, Ms. Smith is here and this is what's going on. I'm not sure if it's this or that or, well, whatever, but consults with that physician. And the physician says, not really clear. I think we need to order, and let's order an x-ray of her ankle. Well, in that case, probably that physician is the one who ordered the x-ray, even though they're not the ones performing, the doctor performing the E&M service. So again, very fact specific, but the answer is different as between those two scenarios.
Wow. Okay. So then that was another light bulb moment like that. What is a referral that you did at the very beginning? Because the scenario that you use, based on what I presented, happens all the time, right? So,
of course.
One rheumatologist had very complex patients, and a good nurse practitioner PA isn't going to just go down every path that he or she could, right? They're going to consult with their doctors. It happens routinely. I know if I'm speaking with them, I know if I'm seeing notes, versus the patient that they go, okay, so you're doing well with your RA, your methotrexate, no signs or symptoms of an adverse reaction, so we're going to order the routine lab, blah, 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 versus the doctor coming in. Oh my God, that is such a distinction with a difference as opposed to the old without a difference. This really is holy mackerel there. Okay, fine. Thank you very much. All right. how can we how can we legitimately distribute income the practice receives for the value-based programs we're involved in? Does Stark have any rules about this? And I know you alluded to the value-based programs a little earlier, but this is, of course, the scenario that most physician practices are dealing with more and more. And not only, now I know that Stark is, Medicare, maybe Medicaid, and clearly with MIPS and direct contracting and other programs that are in existence and will continue. And I believe you may address it, that there have been some flexibilities, I guess, that Stark has put into place with these. So how can the docs distribute income based on the result of their value-based programs?
Yeah, so at the end of 2020 now, I guess I'm like most people because of COVID confused about what year it is. It promulgated some new regulations that, among other things, addressed value-based compensation arrangements, which of course have become so prevalent and are, will just continue to dominate the landscape as we move forward in one way or the other. Because what was happening was the Stark rules as they existed didn't really properly allow value-based programs to engage the physicians from a financial perspective, because how the money could be distributed from the practice that might get the value-based payment to the actual physician was limited based on the then current exceptions. So what's the value-based exceptions are complicated. The definitions are circular, and we could do a 5-day webinar on it and still not quite understand all of it. But one thing is clear: if a rheumatology practice has a relationship, it is participating in, or it could have its own value-based program, actually, as long as it meets the definition. But more often than not, might be participating in someone else's value-based program from which they receive payments based on performance, and want to all share that with the physicians in the practice, who are the actual ones who are driving those payments based on their care of the patient. If the money is from the value-based program, the value-based enterprise, as it's called in the regs, that money can in fact be shared, even though it's Medicare money at the end of the day, based on the volume or value of what the doctor ordered. So the doctor could in fact, under this exception, be paid for each, let's say, X-ray ordered. But that being said, you still have to worry about state law. But the other thing, the big potential problem here, and what already is occurring, and I'm already, I get a lot of questions about from practices, is, well, we participate in a value-based program, but of course, not all of our whatevers are done as part of the value-based program. But can we still distribute all of the revenue from X-ray, for example, based on the volume or value that each particular doctor ordered? And the answer to that is clearly no. And so you have to be able, if you're going to do that, so let's say you are participating, in a value-based enterprise, and you want to distribute money to the doctors based on what they order. You can do that so long as you're able to, 5 years from now, when the whistleblower sues you, you're able to prove where that money came from, and that the only thing you were distributing in that way that otherwise would be impermissible under Stark is money coming from the value-based enterprise. You got to be able to follow the money, as they say. I know there are a lot of medical practices who think, oh, great, this is a get out of jail free card. I can just distribute all of the revenue this way. And the answer, that's clearly improper thinking. And so, yeah, there is this exception for value-based money, if you will, and how it can be distributed, but only that money. And you have the burden down the road, when challenged, of proving that's what you did.
All right, thanks. All of this is more complex than even I realized, as someone who, has played a lawyer on TV. So, so I before I asked Dr. Sue to look for the questions, and I know there are some questions that you guys are posing, I want to make sure that everybody understands that the discussion you just got, not my scenarios I made up, but the thoroughness and down to earth discussion, answers, responses to these scenarios by Lester Perling should be considered really invaluable. I hope that everybody really appreciates the degree of expertise that you've been exposed to this morning. So that's it. My piece. All right, Dr.
Thank you, Jean.
Sue, I know there are questions in the question box. I don't know about chat. So what do we got?
Yes. I think, yeah, I think they're mostly in the question box. So we'll hopefully go through these, have time to do that. And I want to thank you both for doing this and agreeing to stay a little bit past 9 o'clock to go over these questions. So, so one question is, if a doctor employs non-prescribing healthcare personnel like dietitian, physical therapists, counselors, and they have them see their patients for, the services like physical therapy, is that a violation of Stark law?
Well, you just mentioned a sort of a laundry list of different types of, practitioners, if you will, most of which I heard you say are not implicated by the Stark law. For example, a dietitian would not be implicated by the Stark law. Physical therapy is a designated health service. And so in order, if a rheumatology or any other practice offers physical therapy or occupational therapy for that matter, or speech therapy, they are designated health services. And so in order to refer for those services, even though they're performed, let's say, by the physical therapist or occupational or speech therapist, an exception has to be met, like any other DHS, like lab or x-ray, exact same thing. But I think if I remember all of the other types of services you listed, they would, like a dietitian, for example, they would not implicate the Stark law.
So let's say I employ a coach for fibromyalgia, and I say, hey, you should go see my coach that I employ. That would not violate Stark law.
No, that's not a designated health service.
Got it. Okay. Next question is, if a doctor has a drawing station in the clinic, draw the blood samples and send them to a local laboratory, the lab bills insurance is Medicare, and a laboratory provides test tubes, alcohol pads, etc. Is it a violation of Stark law?
Well, the collection materials, if that's what you're talking about.
Yeah, because there's that sort of like remuneration, right? You're getting the supplies from the lab.
I think not. I think that's certain supplies at least are commonly furnished by the lab because they need to be. Test tubes, maybe not. Cotton swabs, Band-Aids, probably not. Those would be problematic. If it's something that is specific to that lab, let's say that there's a lab that does a unique test and the specimen, let's assume it's blood, has to be collected and processed in a certain very specific way, and they have very specific collection devices that have to be used, that's one thing. If on the other hand, you do the phlebotomy and you're just collecting, generic blood samples in generic tubes, that's probably something that the lab should not be furnishing. There's a kickback issue there as well because the doctor's office is the one being paid for the phlebotomy and the expenses associated with the phlebotomy. So it could, there are some counter arguments to that. Is like many things in the law. Unfortunately, not everything is black and white. So I will note that, interestingly, phlebotomy is a DHS. It's commonly listed in the clinical laboratory CPT codes, but it's also an incident to service. And so, but that's a side note. Phlebotomy itself is even a DHS.
What used to be, in that scenario, though, what used to be very problematic, and thank goodness I haven't heard of this happening in the very recent past, was the labs that would provide the phlebotomist to the doctor's office, and the doctor would be billing for the venipuncture, the 36415, right? That, I remember those scenarios used to come up a lot, and my hair used to curl. So.
Okay. So next question is, if a doctor is opted out from Medicare and Medicaid and they do musculoskeletal ultrasound, charge a patient flat cash fee, does that apply? Does Stark law applies?
Stark does not apply if the physician has properly opted out of Medicare because no claim is being submitted to Medicare. It's not a Medicare covered service at that point, even though it would be if the physician had not opted out. And just the reason I say properly opted out is I find that there's a lot of misunderstanding by physicians of the difference between being participating and non-participating versus opting out, because they're very different things. So a side note, but yeah, if the doctor has properly opted out, then the Stark law is irrelevant to that practice.
Yes.
At least to that doctor.
Yep.
But you did mention, though, that some state laws do not.
State laws could still apply. So, yeah, so for example, in Florida, the doctor has a clinical lab, owns the office, has a clinical lab, has opted out of Medicare. Stark would not apply. However, the Florida version of the Stark law in that case is payer neutral, applies to all payers, including the patients themselves. So in that scenario, the doctor could not order the lab test unless the doctor met an exception under the Florida law, and there's exceptions. So again, state law always has to be considered.
Okay. Let's see. Next question is about selling supplements in the clinic or non-prescription infusions.
So
is that a violation?
those things are not covered by Medicare, and so therefore not covered by Stark.
I mean, I guess anything you sell in the office is not covered, right?
Anything that's retail, over the counter or whatever, is not covered. Now, as you know, some durable medical equipment is covered. There are, there's some things that like you can buy at CVS or whatever that could be, I guess, sold in a doctor's office that would not be covered. But yeah, if it's not covered, it's retail, it's over the counter, whatever. Stark doesn't apply.
I mean,
State law might, but not Stark.
Oh, okay. So some state laws do not allow us to sell supplements and things like that?
It's something you got to look at. In Florida, again, with the Patient Self-Referral Act, it talks about healthcare items or supplies. And so what's a healthcare item? There's no definition. So it gets
okay. That's interesting. And some of the DMEs are not covered by, let's say, wrist braces, and patient pays cash. And you say, hey, I sell some braces. Would that violate Stark law for Medicare?
If the brace is not, Medicare does cover wrist braces, but if the brace that's being sold is not the type that is covered by Medicare, then it would not implicate the Stark law. It's something to be careful of, that if the physician decides I'm going to buy these same types of braces, for example, that CVS and Walgreens sells, you better make sure that you're not ordering and selling that in lieu of what would be a more medically appropriate device that Medicare would cover, but you're trying to avoid the Stark law, and you're costing the patient money they may not otherwise have to pay, and the patient complains. There could be an issue with that. So, but yes, if it's not covered by Medicare for whatever reason, then the Stark law would not apply.
If it is covered and you submit the billing for DME, would that qualify for the exception because it's in office?
Yeah, it can, as long as it's properly dispensed within the office.
Okay.
Yeah.
Next question is, my wife is a nephrologist in a 45 provider group. Are patient referrals prohibited between the different specialties in that group?
Between the specialties?
Let's say you have a nephrologist, you have a rheumatologist, hematologist, and they all refer within each other. The
Stark law, while the professional component of something like an X-ray or pathology is a DHS, an E&M service would be rendered based on a referral for a consultation from one physician in a group to another, is not covered by Stark.
Okay. Next question is, what if
one thing that brings up something I want to mention, because it's often more often than you would think a problem, you have spouses who are physicians, but don't work in the same practice, might be different specialties. So let's say you've got, Mrs. Dr. Jones is a rheumatologist, Mr. Dr. Jones is an internist. Mr. Dr. Jones doesn't have X-ray or lab in his office. Mrs. Dr. Jones has both in her office. Mr. Dr. Jones wants to refer to Mrs. Dr. Jones to get X-rays and lab work done. Because that's his wife, an immediate family member, that means Mr. Dr. Jones also has an imputed ownership interest in Mrs. Dr. Jones' practice, and doesn't meet an exception. And so referrals between spouses for DHS who are in different practices could potentially violate Stark. In Florida, the actual referral to the practice, even for the physician service, can violate the Florida Patient Self-Referral Act. So, husband and wives are in different practices, and, it's not that uncommon. Need to think about that and referrals between them, for DHS, and whether or not there's going to be a problem, and whether or not they should perhaps, in that circumstance, decide to be in the same practice.
Yeah. And I'd like to add, since not every physician's spouse is a physician in the healthcare arena, because as you're talking about that, Lester, I can think of a physician that I worked with that his wife opened, I guess it's still DME, but only for the glucose testing strips, et cetera, for the diabetic patients that get mailed out. And the physician, actually, when we were discussing it, told me that he was a part owner in the practice with her. And it was clear even to me that there were some very serious Stark implications there, and had referred him on to healthcare counsel. And long story short, he was quickly no longer an owner in the practice. And two, wasn't referring any of his own patients over there to his wife, right? So, yeah. So
even if he wasn't an owner, he couldn't refer because his wife's ownership would have been attributed to him anyway.
Yep,
So
exactly.
Yeah.
I guess if your niece has a pharmacy and you refer patients, or the patient fills medication there, would that?
I think if I'm remembering correctly, niece is an immediate family member.
Oh, immediate member. Okay, got it. That's good. All right.
I don't remember the full list, but it's fairly broad. So.
Okay. We have a few more questions. So what if home health or hospice or any agency you contract with reimburses you based on the specific services you submit in a timesheet monthly? Is it okay to refer to them? So I guess you're referring your own patients to hospice, home health.
Well, hospice is not a designated health service, so it doesn't matter for Stark purposes. Home health is a designated health service. So a physician who, let's say, is a medical director, of a home health agency or or a medical advisor or whatever, is prohibited from referring to that home health agency unless the compensation arrangement between the home health agency and that physician meets an exception, and there are a couple of exceptions that could apply. The compensation arrangement, if it in part varies, so let's say the home health agency pays the doctor to review each new order that they get for some odd reason. That's probably not necessary, but let's just pretend that's okay. It would be fine if they pay the doctor for each order, so long as it wasn't an order or plan of care that he signed. So as long as it doesn't vary with the volume or value, and otherwise meets an exception, then that's okay. But that does create a stark financial relationship between the doctor and the home health agency.
Okay. Next question is, I want to clarify, infusion therapy or biologic is not considered DHS, and can the profit be divided by the volume ordered? I think that's correct. We already talked about that, right?
Well, it is DHS, but it's an incident to service, and therefore can be shared based on who it's incident to, which is typically the ordering physician.
And if the employee physician, so you indicate that the owner physician could decide that they are not sharing that profit, that the owner keeps everything, or they could decide to share that profit. It's just there's no relationship to Stark law with regard to that. Is that correct?
Oh, no, there is. How they share the profit with either between owners or between, the practice and employed or contracted physicians is definitely regulated by the Stark law.
For the biologic though, the infusion therapy, because it's
Well, again, if it's being distributed to the physician under whom the incident to service was ordered, yeah, then it can be shared based on the ordering physician.
okay. Any possible Stark law or anti-kickback issues with Sound Room Diagnostics? It's a company that has other rheumatologists in another state interpreting diagnostic musculoskeletal ultrasound images that are ordered by primary rheumatologists who has a sonographer machine. And this company gets professional fees while the practice gets the technical component.
No, if the entity, the practice that's doing the interpretation is billing for the interpretation, and the practice that does the technical is billing for the technical, there's no issue with that.
Okay.
Now, if the interpreting practice or the interpreting physician is billing the practice that ordered the test, and then the practice bills globally, it may not implicate the Stark law, but it does implicate something called the Medicare anti-markup prohibition and could be a problem. So while we're not going to talk about that today, those relationships can implicate Stark, but they can also implicate other Medicare billing rules that the practice needs to be aware of.
Okay, let me see. I think there's another question about the IV therapy have to be shared equally among the rheumatologists, or can there be tiers? So I think, I think I'm still a little bit, so I understand that with ancillary services like radiology, the physician owners or the owners of the practice, they could decide how to distribute that. And it's not based on volume, right?
Right.
But when it comes to IV therapy, it could be based on volume because, like you said, it's incident to. So, so let's say physician X has 10 infusions. The owner practice could decide that I'm going to give you 50% of that because you've been here for 1 year, and then if you've been here for 3 years, I'm going to give you 75% of that, right? And that could be based on volume. Or the owner could decide no one gets any infusion profit because you're employed until you become an owner or a partner. Okay, very good. All right. So let me see if I have any other questions here. Accepting lunch regularly from pharmacy companies in compliance with Stark law. Actually, I have that same question. They drop off donuts and things like that. Is that in violation of Stark law?
Well, it could be a violation of the federal anti-kickback statute, but pharmacy detailers work for the manufacturer or the distributor, and those are not covered by Stark. What's covered by Stark is the actual dispensing pharmacy that is submitting the claim. So the financial relationship that's created by the acceptance of a gift from a drug detailer working for a distributor or manufacturer does not implicate the Stark law. Could implicate other laws. And plenty of doctors have gotten in trouble for their relationships with pharmaceutical manufacturers and distributors, but not because of the Stark law.
And I would just add, since that happens so often, the lunch in a rheumatology practice. I know one rheumatology nurse who's been with the practice for years has told me she's never had to buy her own lunch. So, but the doctors, just a reminder, it's again another topic, but just a reminder. Remember, there's this open payments rule. And if you do not go out, you the physician, and check what gifts, lunches, whatever it is that has been provided to you by pharmacy, device manufacturers, etc., they have to report that. And it behooves you, the clinician, to look at that list when it comes out every year. I think it's actually out about now for doctors. To see if it shows that you got $50,000 in 2021 from these 3 pharmaceutical companies. Did you actually get $50,000, right? or not, because you wouldn't want those dollars to be attributed to you as gifts, right? When it's not so, right? So that's another consideration to think about when it comes to accepting things from pharma.
You know, I have radiology facilities that drop off gifts, like mouse pads or, you know, calendars. It seems like that would violate Stark law, even for.
I mean, it arguably is an in-kind remuneration, you know, whether while those gifts and calendars go to the practice, or they might end up in the home of the receptionist or the medical assistant or whatever, you know, is remuneration to the physician is a bit, you know, it's theoretically could be, but there'd be strong arguments against, you know, if on the other hand, they drop off, you know, 6 boxes of gloves, you know, that is going to financially benefit the practice and the doctor who owns the practice, because now they don't have to buy the 6 boxes of gloves. That probably would be a stark financial relationship, believe it or not. So kind of, you know, it as so many things, the answer may be it depends, but you got to be leery of all of that. You know, if I were running a medical practice, I would just say, you know, no thank you to anything like that, and just avoid any potential problem. You know, because whether or not it's a problem, it ends up being, if it's a problem in the eyes of a third party, and you're just better off. It's not worth it to accept. Look, if a detailer brings a pharmacy, you know, drug detailer brings a box of donuts, that's fine. But you know, you got to be, you know, it's, I think, prudent just to say no, thank you.
So Dr. Sue, if there's one more question, let's take that, and then we can let people go on their way, and I'll let them know about the recording.
Great. So one more question, I think this might have been answered already, is with disclosure to the patient, I'm referring the patient to a nephrologist practice where my wife works to protect you. I wonder if this is like the EM services that you're talking about. You said it's not applicable in Stark law, for Stark law, under Stark law?
For an E&M service, no, but it raises an interesting point. States like Florida do have laws that require physicians to disclose financial interests in different situations. And for example, in Florida, if you're a physician and your employer owns 10% or more of something to which an entity that you're referring a patient to, like let's say an imaging center, while that referral may not be prohibited under Stark, because you don't yourself as the employee have an ownership interest, but your employer does. In Florida, if you don't tell the patient and disclose that to the patient, believe it or not, it's a crime. So states have, and the Stark law contains some disclosure requirements for advanced imaging, which is MRI, CT, and PET, and requires patients be given a document with choice. So there's lots of different disclosure requirements, including under Stark, that may apply in a given situation. So, you know, another word of caution. I think if anyone's still practicing medicine after this webinar, I should try.
Oh, love the humor. What a great note to end on, Lester. Oh my goodness. So the webinar, as you all know, has been being recorded. My office will go through it, make sure there aren't any blips. I think everything went smoothly, so probably no additional work. And Laura will send out to each of you instructions and a link as to where you can access if you care to listen to this again, or there's a point that you go, wait a minute, what did they say about this? And Dr. Sue, I want to thank you so much for moderating the questions. That you did such a great job, and it really was a help for Lester, I'm sure. And Lester, my goodness, the star of the Saturday morning. Thank you so very much.
You're welcome, Jean. And I just want to make sure, you know, the attendees understand that, you know, this discussion has been really general. And so, you know, as to your own practices, which always have unique little twists and turns and components, you know, make sure you know, it's worth investing with somebody who's qualified, to get advice regarding your specific situation, just to make sure. So, we've talked about things very generally, but you got to make sure you understand how they're going to apply in your situation.
Yes,
Yeah.
most definitely.
Thank you so much. Thank you. Alrighty. Have a good rest of the weekend.
Thank you, everybody.
Bye.
Take care. Thank you. Bye.